Ready, start. Learned counsel for the appellant has pressed the appeal only on the question of the applicability of Section 302 read with Section 149 IPC to the appellants other than Ramakant Rai. Full stop. It was urged that according to the findings of the court below, the occurrence took place in the disputed field which was claimed by both the parties. Full stop. According to the prosecution case, the field in question was in the possession of the deceased Janardhan and PW1, and they had sown arahar crop and had come to harvest the same. Full stop. At that time, the accused in a body arrived at the scene variously armed, with a view to dispossess the prosecution party by force. Full stop. There was exchange of brickbats and ultimately one of the accused, Ram Sevak, who was armed with a gun, fired a shot which hit the right eye of Janardhan, as a result of which he fell down and died instantaneously. Full stop. The appellant Ramakant Rai is said to have provided a cartridge to Ram Sevak before he fired the gun. Full stop. In these circumstances, therefore, the conclusion is inescapable that Ram Sevak and Ramakant Rai had undoubtedly the common intention to cause murder of the deceased. Full stop. As regards others, on the materials, we are satisfied that the occurrence took place over the possession of land claimed by both the parties. Full stop. Apart from Ramakant Rai and Ram Sevak, no other person of the assembly took part in the assault on the deceased. Full stop. Although some of the appellants were armed with farsa and spear, and one of the appellants with a pistol, but none of these weapons were used. Full stop. In the circumstances of the present case, there can be no doubt that the appellants had gone armed in order to dispossess the prosecution party and cause such injury as may be necessary for achieving that object. Full stop. But the evidence does not show that all the appellants shared the common object of committing the murder of Janardhan. Full stop. It is true that the mere fact that no overt act has been attributed to the members of the unlawful assembly, is not sufficient to disprove the charge under section 149 IPC. Full stop. But this question depends on the facts of each case. Full stop. In the instant case, we are satisfied that at the most the appellants other than Ram Sevak and Ramakant Rai had merely the intention to cause an offence under section 325 IPC and were, therefore, guilty of offence under section 325/149 as also of rioting. Full stop. The other question that has to be determined is as to what sentence should be awarded to the appellants. Full stop. The appellants have served only 3 to 4 months and have been on bail throughout. Full stop. It would not be conducive in the interest of justice to send them back to jail after a lapse of 10 years. Full stop. On the other hand, if the family of the deceased is heavily compensated, that will serve the socio-economic purpose which the modern trend of the policy of sentencing required. Full stop. For these reasons, therefore, we alter the conviction of the appellants except Ramakant Rai from 1 under section 302/149 to section 325/149 and reduce the sentence to the period already served. Full stop. In lieu of sentence remitted, we impose a fine of rupees 5,000 on each of the appellants in default to 2 years RI, full stop. The entire fine, if realized, shall be paid to PW1, the widow of Janardhan. Full stop. The sentence under section 147 is also reduced to the period already undergone. Full stop. As regards Ramakant Rai, there is evidence of the eyewitnesses that he was the person who supplied cartridge to Ram Sevak in order to shoot Janardhan. Full stop. In these circumstances, Ramakant Rai is convicted under section 302/34 and his sentence of life imprisonment is upheld under this section. Full stop. The appeal is dismissed. Full stop. Fine to be paid in 6 months. Full stop. After the fine is paid, the appellants shall be discharged from bail bonds. Full stop. We have examined the evidence. Full stop. We have perused the post-mortem notes of the deceased. Full stop. PW17 was working as an assistant surgeon in the hospital at the relevant time. Full stop. On 2nd November 1989, the injured witnesses, as well as the deceased Lakshman, were brought before him for medical examination. Full stop.